Before I start this video, I want to preface it with this is not legal advice. This is just my experience, my perception from the last 12 years in family civil law. So I also want to preface it with it is a fact that the state of Florida has an issue with child support, has multiple issues. There are many mothers and fathers that are chasing down, seeking child support from a parent that is deadbeat. There's an issue with that. That's a fact. It doesn't negate what it is I'm about to say. The problems that I face are more about the procedure and the intention of the Department of Revenue to collect funds versus being fair. So, if you believe you are paying too much in child support and you feel like you want to change it, you should know that the child support program is not designed to be fair. It's designed to maximize collections. And when you look at it closer, the more you unveil, the more things point to that intention. There are incentives for performance. They get reimbursement from the federal government, reimbursement from the state for administrative fees that sum up to about $260 million a year. The performance incentives reward them, the agencies, for collecting child support on how much they collect, not how much they pay. So what happens is there is a direct correlation with the intention to collect or increase child support or increase the number of individuals in the child support program than there is the intention to make sure that it's fair. That being said, I'll use my particular child support case as a reference. This is public information, so this isn't something that you couldn't go find out for yourself. So I'm going to keep all the private information as private as possible. But let's begin. I did have a job working for a very large construction company, and they fired me in 2021. So upon being fired, I had filed a petition to modify child support based on that change in circumstance, based on the loss of income. And this is when it really started to become apparent how unfair the child support program is. The child support hearing officer and the Department of Revenue attorney seem to work in tandem to resist any downward modification. Some of the same arguments they had for the petitioner, which is the mom in this case, wouldn't work when I made the same arguments. An example of that would be she had quit working voluntarily. The court had notice of this. There's a final supplemental judgment that states that she had willfully left her job at Disney. And I have a deposition where she also states that she was employed at the time working for Disney and was going to become a housewife and no longer continue to work. So it was voluntary. And if you have voluntary unemployment or underemployment, the child support program is supposed to impute a salary for you, and it starts at minimum wage and can go up to the median wage so long as you've had the history of earning that kind of money, or if you show that you are trying to hide it. So moving fast forward, it's been a few years, and her income was imputed at minimum wage, which was substantially less than what she was able to earn prior to. And because minimum wage is imputed for her salary and minimum wage has gone up $1 every year, it's went up $2. It will be $3 in September since the last order. So I filed a supplemental petition to modify child support on December 6th. It wasn't until the 15th of January that I received a notice of hearing. So that's a month later. The same day, I received an answer to petitioner's motion to answer. Actually, I should say it correctly. I only received the notice of hearing via mail. They were serving me via email, and it was going to my junk mail. Apparently, some of the updates with Apple summarizes some of your emails, and I wasn't getting notifications like I was before, or at least all of them, and I missed emails, but they are supposed to notify me by mail. So they sent me a notice of hearing by mail. They emailed me an answer to petitioner's motion to answer supplemental petition DOR. So their answer to the petitioner's motion means that they are answering the mother's motion to answer my supplemental petition. There is no such motion filed by the petitioner. that doesn't exist. However, they had already scheduled a hearing for an unknown matter on the 15th, the same day they are filing an answer. Then on the 24th, 9 days later, they motioned to intervene and transfer case for determination of child support by the child support hearing officer. Now, this is something that I have a little bit of experience with. My first interaction with them was in 2016, I believe. I went to a cattle call type hearing where there is several families in there at once, and you get called up one at a time. They have a rinse and repeat program. The hearing officer and the Department of Revenue attorney, they are the same ones from 2016, probably prior to that, I wouldn't know, but they work together every single day, and it's almost as if the right hand knows what the left hand is doing when you're in those cases, or when you're in those hearings. On the 24th, they filed a designation of email address. Now, what I find interesting about the designation of email address is each time that this case is reopened, so if there's a petition, it opens the case, and if the judge makes a ruling on it, it closes and there's an order, and then the case is closed. Every time that it's reopened, if you look at the history, there is a new designation of email address by the same Department of Revenue. However, they are serving me via email, and I haven't designated my email address. And there's a form for it. I can't remember the number, but if you don't file that form per the statutes or procedural rules, your designation of email isn't up to date, and they can't solely rely on email. They can send it to you, but they must send it by regular postal mail. That's the default. So at this point right now, the only thing that I have received was the notice of hearing. Then on the 31st of January, there's an order authorizing intervention and transfer of case for determination of child support by the child support hearing officer. So basically, my judge, 7 days later, ordered the authorization of the intervention child support hearing officer. In their motion to intervene, there was no notice that I could object to it. Usually with magistrates, they'll put it in there that you can object to it. I believe I've seen it in the past. I'll probably go back and look at some of the previous motions to intervene whenever you have like 10 days to object to it, and it defaults to your circuit court judge. So I just so happened to look at the docket on January 31st, because mind you, I'd only received the notice of hearing on the 15th or just after that, maybe the 17th, and nothing after that. So I go onto the docket and look at it on the 31st, Friday, and realize, well, dang, there's been some activity, and the judge has already ordered this authorization for them to intervene. So I motion to vacate the very next business day, Monday morning, February the 3rd. I motion to vacate the order and basically explain everything that I just said about not being notified. What's significant about it is on the 10th, one day before the hearing that they gave me notice for that had no proceedings listed, they filed an answer to supplemental petition for modification. So the issue with that is that if you look at the answer to petitioner's motion to answer, which we'll look at it now, the title matters. It says DOR's answer to petitioner's motion to answer. This was on the 15th. Comes now the Department of Revenue by and through its undersigned attorney and responds to petitioner's motion to answer supplemental petition and states the following. This paragraph here is a direct response to my petition to modify child support. The title says that they're responding to the other party's petition, or I should say the other party's motion that doesn't exist. If you look through here, and you can pause to read, you'll see it doesn't exist. There's nothing filed. Then on the 10th, they file an answer to supplemental petition for modification. That's how it's titled on the docket. When you open it up, the title on the document says DOR's amended answer to supplemental petition to modify child support, amended to reflect the correct pleading being responded to, meaning they're correcting their last answer, which also means that the hearing set for the 11th was improper. So what this means is the hearing set on the 11th was improper, and I was not properly notified because the proceedings don't line up, and there is no motion tied to that proceeding. Again, this answer is an amendment to the previous one, and all of that paragraph right there is responding directly to my petition. This is the day before the 11th hearing. So I go into this hearing, and it's another cattle call where there's several families there, and I actually go first. Calls me in, we go and we get sworn in, and he explains that we are there to hear the petitioner's motion to answer. And I'm like, what? I said, I'm here because I believe that we're supposed to be hearing my supplemental petition to modify child support. That's what this notice says, because everything's responding to my petition in the paragraph, in the body of the document. So then he responds to me saying, well, you've got a motion to vacate the order for intervention, and that hasn't been heard yet. Do you wish to have me hear your petition? I said, well, I came prepared to present my case for that because that's what I was informed of, or at least interpreted by the documents. And he said, if you're ready to hear it, I'm prepared. He took that as a withdrawal of my motion to vacate. If anything, I would say it was conditional on the fact that he would hear it, because I said I was prepared. I didn't say I was prepared to come back later. I was there to hear my case. But what ended up happening was, because he was in the motion, or in the gear of hearing the petitioner's motion to answer, she gets the floor, because a motion calls for a hearing. If you just answer, you're just answering, and you go to the proceeding or the hearing and you answer to whatever it is that's being pleaded. He gives her the floor, says, ma'am, are you ready? And she goes, well, I don't really know. I was just told to be here, but I don't know what's going on. He didn't give me anything. I don't know what he's making. And a correspondence saying she works 12 hours a month at minimum wage at the Ocala Civic Theater, which is crazy that they just accept that. That's okay. It's okay. I filed a financial affidavit, so I'm showing them, or at least voluntarily telling them what I'm making. So he responds to her saying, well, ma'am, are you asking for a mandatory disclosure? For one, if she actually did motion to answer and requested that in her pleading, then that would have been okay, because she had actually asked for it. But because, one, she didn't file a motion at all, and he led her to it, it wasn't arrived to organically. So he led her into asking for mandatory disclosure, which is mandatory, but a lot of times hearings will go on. If nobody asks for it, they just take it on face value and they move forward. And in my case, I'm just saying, hey, listen, her minimum wage has gone up. She's no longer imputed at $11 an hour. It's $13. That's $2 an hour, $80 a week. So that's significant. And it only takes $50 or 15% change for it to constitute a change in circumstances based off the guidelines worksheet. Make note of that. So he continues my hearing, basically delays me moving on with my petition, though this entire thing was started and I'm the owner of the entire proceeding. Like, I'm the one that called it to be heard. I should have had the floor, but they hijacked the hearing. Another little note here too is that the hearing officer referred to the Department of Revenue's representative or associate, asking him what information he had on both parties. And he explained, I have minimum wage for her. I think it was like $2,600 a month, what he said. I'm not sure. And this is testimony at this point, because he's asking questions and they aren't sworn in. So that's a procedural error. The next thing is, the Department of Revenue has the only attorney in the case. And attorneys are required to correct any errors in the pleadings or procedural errors. He's the one that files this petition here and their amended answer the day before. If he doesn't know, he should, and if he does know, this was intentional. So this particular DOR's amended to supplemental petition, you can't amend something if you didn't already put it in there. So that right there in the title explains that the previous one was to my petition. And their answer was the only reference to any possibility of a petitioner's motion to answer. So it's just, you can tell this is a mess. And he should have said something. And as a matter of fact, I believe there are sanctions that could be imposed upon him for not doing so. I could probably go to like the Attorney General and bring this up, because this is not fair. So ultimately, I filed this in December, beginning of December, and we won't go to hear her motion to answer until April 15th. So that's a huge delay. So it just goes to show you that, again, the child support program isn't designed to be fair. People have the assumption that, oh, it's a fair process. They go into it thinking, let's consider everybody's income and all their expenses and come up with a fair number. No, their intention every time is to increase the obligation of whoever it is that's paying. And it doesn't matter if you're male or female. If you just happen to be female and you are the non-custodial parent, guess what? They're coming at you with everything they got, and they will file petitions. So what I plan to do is journal this entire process, this experience, and publish it later. Maybe make a book, a little video, a self-help deal, not legal advice, but just giving real world perception on how this stuff works. And I want to close with this, is that in Marion County, the hearing officer, Raul Rojas, and the Department of Revenue's attorney, Mr. Warshaw, they've been working together every single day. And if you want to, you can go into those child support hearings. It's public, it's a public forum. Just go and observe. And if you sit there for any amount of time, you will see a pattern. And it is not fair. And it's not in the best interest of the children. It's not in the best interest of anybody but the Department of Revenue.